is in re NW and SW. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims in your argument if that applies, and you can refer to them by initials or terms like the child. We have read your briefs and are prepared to proceed when you are.
Good morning, Your Honors. May it please the Court, Joseph Schell from Summit Legal Defenders on behalf of the appellant, Juliana Lovejoy. Your Honor, I'll reserve 2 minutes for rebuttal. There are only 2 exceptions to adopting a child without a parent's consent. Because adoption terminates parental rights, imposes on the parent the death penalty of family law, those exceptions must be strictly construed and, when possible, resolved in the parent's favor. Regarding the maintenance and support exception, the trial court did not do that here. It committed legal error when it failed to consider...
I hate to ask a question so early.
Of course.
But I did look closer at the record, and it looks like the money from the tax confiscation of the refund was actually went all to arrearages. Does that change your position that 99% of the support was paid during that year?
No, and actually I think a clarification probably from my brief is warranted here. So what Ms. Lovejoy owed during that 12-year period is at most $360 per child. I think it's unclear to me whether she owed $25 or $30 a month per child, but let's say it's 30.
I'm sorry to interrupt you again, but there really isn't a support order entered as evidence in here in the record either, is there?
No, there isn't, and that's the Weaver's burden to present evidence that she did not pay the support that's required by law or judicial decree. But given what we have in the record is that we know that there was a payment made during the look-back period, right? That seized income tax return payment was confiscated in September of 2022. There's no dispute that's during the look-back period here. And it's for more than the full amount that she owed during that year. She owed $360 at most per child for a total of $720. That seized return was for $1,011. So that's 140% of her annual obligation.
And in one of the briefs, and excuse me for interrupting, it's a factual question, seemed to state that after that payment was made, there was $10 due and owing on support. Is that in the record somewhere that we could find? When you say the order's not there, is that somewhere in the record that we can say that that's accurate?
So yes, it requires a little bit of math that's in the brief, and I think that's in the footnote in a footnote in both the opening and reply brief. So it's record items 8. And then exhibits A and B to record item 53. That's where all these support orders are. So record item 8 is the support payment history that the Weavers submitted with the adoption petition. And then exhibits A and B to the magistrate's decision are the payment history that Ms. Lovejoy submitted. So
I have another question. I'm sorry. This is very fact-based.
Yep.
Because we're supposed to presume from that document that there was some support order way back when, are we supposed to be using that number for now? She did testify she had a job, that she was making income during the period of time. Are we supposed to presume that her current obligation was 25 because we can somehow make that logical jump from past records?
you don't need to make any jump, Your Honor. Both the payment histories that the Weaver submitted and that Ms. Lovejoy submitted, there is a line there that says what the monthly obligation is. And so even Ms. Lovejoy's submission, that was in December of 2023. So as of that point, her monthly obligation was $30 and some change, I think $30.60-something cents. So no, there's no jump that you need to make. At most, it was $30. Now the testimony was that she owed $25 a month. So we can take the high end of that. If the court likes.
Whose testimony was that? When you say the testimony, that had $25.
I believe it's Ms. Lovejoy's testimony that she owed $25 a month for the support order.
Not the petitioner. Did the petitioner ever testify as to what was owed in support per month?
I think Ms. Weaver testified that she received maybe $5 a quarter from Child Support Enforcement Agency. The child support payments, though, the payment histories paint a pretty different picture than that. And I think, Your Honor, to your question about whether she had a job, whether the support payment was different, I think that goes more to the justifiable cause point. This first point here is really a legal question, and I think, again, maybe some clarification from the brief. I think I sort of undersold the standard of review here. I think it is a legal question whether this seized income tax return constitutes support, and then it's a factual question about whether, given that amount of that support, that it satisfied her annual obligation during the period of time.
And I think the other, don't you agree, the other legal question is if it goes to arrearages, is that a payment? I mean, it's not a payment for current support, it's credited towards some past support.
Well, that's not how the Supreme Court of Ohio has looked at it. So I think even in In Re ACB, which the trial court relies on as sort of settling this issue that a seized income tax return payment does not constitute support, I want to make one preliminary point here, that ACB says absolutely nothing about the source of the payment. The Supreme Court of Ohio doesn't say it. The 6th District, even before this case went up to the Supreme Court of Ohio, doesn't discuss the source of the payment. But to your point about whether this should count as arrearages or support during the look-back period. So in ACB, there was one payment of $200. The court noted that he was required to pay a total of $4,420 during that year. Those were the two numbers that the court compared, despite the fact that the appellant in ACB had $17,000 in arrearage. So it's really only about whether there was a payment made during the look-back period and what the amount of that payment was relative to the annual obligation, also during that look-back period. Here, I don't think it makes a difference, though, because we know that Ms. Lovejoy's support, at most, was a total of $720 for the two children. Her return, the evidence that was submitted, both by the Weavers, who again have the burden of showing that Ms. Lovejoy did not pay the required support, and the evidence submitted by Ms. Lovejoy, show that at most she had a total outstanding balance, I think this includes arrearages before that, Your Honor, of $1,021.70. So I think at most there's a $10.22 arrearage total, including what her obligation was before the look-back period, but there's no question that her seized income tax return payment satisfied her full obligation during the look-back period.
Do we really have in the record what her current support obligation would be? We're talking about a potential past obligation, probably based on whatever her income was at the time or circumstances. So can we really use $25 as the standard here?
Well, Your Honors, you don't need to know what her current support obligation is. It only matters what her support obligation was from October of 2021 through October of 2022. And it was the Weaver's burden to submit evidence of what that was.
Because we have cases where there's no support obligation and then there's supposed to be some kind of present determination of what the obligation is, right? So how could we just say her presumed $25 from back then is the same as what she should have paid or should be paying in the present?
Well, it doesn't matter what she should be paying in the present. It matters only what she should have been paying from October of 2021 through October of 2022.
Right.
That's the look-back period.
During that period, right?
Correct.
What her obligation should have been or should be during that period.
Correct. I think both the Weavers and the Lovejoy and Ms. Lovejoy's evidence, I don't think there's any dispute that that payment or that support obligation was not $25 or $30 during that period. And again, it would have been the Weaver's burden to show that the obligation was more and that she failed to meet that. What we have in the record, based on the evidence that the Weavers submitted, their evidentiary burden, is that at most her obligation was $720 for the two children. And her seized income tax payment constitutes 140% of that obligation. So I think the only two questions here are, on this first issue, is does that seized income tax return payment constitute support? The answer is unquestionably yes. Not only is there no authority for the trial court's position that it doesn't, but there's 30 years of precedent that unanimously hold that it does constitute support. The Sixth Circuit in 1993 held in Kessler that a seized income tax return payment, quote, constitutes support. The Eighth District in 2002 also said that the fact that a payment is made via a seized income tax return does not diminish the parent's support.
But in that case, do we know if that ceased payment went towards current obligation or arrearages? Because that's, again, arrearages is not current support, it's like it goes to a debt.
So in the sixth district case in Kessler, yes, it went to arrearages, and they still said that was a payment that constitutes support. Whether it goes to arrearages or current support, though, is the Weaver's burden, because they have to show that she didn't provide support.
But didn't they meet that burden by having the CSEA show that it went to arrearages only?
There's no evidence that it went to arrearages. There's evidence only that of what her outstanding balance was and what the payments were. And when you look at what her outstanding balance was, as of the latest point that the Weavers submitted evidence on, which was July of 2022, her total outstanding balance as of that point was $1,021.70 for both children. Her seized income tax return payment, seized 2 months later, paid all but $10.22 of that obligation. That's 140% of her obligation during the look-back period, and it constitutes 99% of her entire obligation that the CSEA records established up until that point. There is no other evidence in the record submitted by either the Weavers or Ms. Lovejoy that there was any other arrearage or that there was any other amount owed, aside from maybe that $10.22. So I think at most, the court could send it back and to do what the Supreme Court of Ohio instructed in the In Re MB, is for the trial court, in its discretion, to analyze in the first instance whether an arrearage of $10.22 outside of the look-back period is enough to defeat the need for Ms. Lovejoy's consent under 310707.
You're heading into your rebuttal time, so
Very good. I'll reserve the rest of them. Thank you, Your Honor. Oh, actually, I'll say a few things. I only wanted 2 minutes for rebuttal. I'm sorry, Your Honor. Because I want to go through the cases too, just quickly, that the trial court relied on. So, right, ACB I think speaks a lot to Judge Lansinger, to your concerns. That again, there's no dispute that in that case that parent had $17,000 in arrearages, but that number is not part of the court's analysis for the look-back period. ACB looked at the $4,420 that that person owed during the look-back period and measured that against the $200 payment. Now I suspect that you're going to hear from the Weavers that, well, right, Ms. Lovejoy had a monthly obligation and she didn't make the monthly obligation, so who cares if there was one payment that satisfied things. That position was also rejected in the ACB. If you look at Judge Fisher's concurrence, that's what he would have said, right, is, well, we've got an $85 a week obligation. He missed a couple of those weeks. So I would say that missing those weeks means that he didn't provide support as required by judicial decree. He's on his own in that concurrence. That is not what the majority said. The majority said in paragraph 15, the legislature has opted for an objective standard for testing whether maintenance and support has been required, and that is, quote, the amount set forth by judicial decree. And that is why the court looked at that. I will reserve the remainder of my time. Thank you, Your Honors.
Good morning. May it please the court, Attorney Corinne Hoover on behalf of the appellant, the prospective adoptive mother. Your Honors, this case is certainly a case of non-support, and it is a case where the trial court weighed the credibility of the witnesses and testimony, as well as examined the records. The trial court did not abuse its discretion, nor was there a manifest miscarriage of justice based on the manifest weight of the evidence. In this case, the prospective adoptive mother testified. She testified that the mother's obligation for support was $25 a month, established by an administrative support order, based on the fact that the children were recipients of public assistance. Ms. Weaver did not seek this order on her own. This was the administrative order done by virtue of the children receiving welfare benefits. Notwithstanding that, however, Ms. Weaver testified that throughout this period of time, that the child support records were clear that mother did not satisfy this obligation. Based on the case law, a prospective adoptive mother's burden was to demonstrate that mother failed to support the children during this 1 year period of time, which she did with her testimony, and that it was without justifiable cause.
On the question of consent, isn't it the petitioner's burden to show that the support had to be paid for a year?
Yes, So
I just want to make sure, you were saying it's mom's burden, I think that's the petitioner's burden.
Yes, I'm
Sure.
sorry, you're correct. So I believe that the prospective adoptive parent's burden is to show did not pay for 1 year and that it was without justifiable cause. After that, then the burden shifts to the biological parent to prove that they had some justifiable cause in not meeting that support obligation.
Isn't this basically a question of law as to whether that $1,000 that came in during the 1 year period is or isn't enough to waive or require consent?
I think it's a question of fact, Your Honor, for the reason that.
Is it a disputed fact? I mean, I don't think the disputed fact that $1,000 came in during the year.
Correct.
The question is, what is the effect of that?
Correct. So it was, you have to look at each child individually. So this obligation was $25 a month per child. So when that $1,000 comes in, it's not applied to mom's overall, but $500 is applied to each of the children. In that, mother's records that she submitted as exhibits A and B, were child support records indicating the payment history. Interestingly, however, mother submitted the wrong set of records. Mother submitted records that were only 6 months of the 1 year look back period. So the look back period was from October of 2021 through October of 2022. Mother's records that she submitted were child support records from January 1st, 2022, more than 6 months into the look back period, through December 5th of 2023. So it was mother's burden then at that point in time to say, to contradict essentially, to present evidence that petitioner is not accurate or has made some mistake of fact or whatnot. Mom's testimony was, here's the records, look, it shows I paid.
Didn't the record show the payment was in September,
Correct.
a month prior to the filing of the petition?
Yes, it did. But, so the records, the applicable period is she demonstrated that as of December 5th, 2023, she was still in arrears. She did not present any information to indicate that she was caught up as of October 2022, which was the end of the look-back period.
I read the magistrate's decision and the court's decision rising and falling on whether or not the money that came from the tax return seizure was applicable to the issue of whether or not she's paid anything within that period of time. And finding that you can't count that tax return seizure.
I don't think the court said you can't count the seizure. I think what the court said was that the seizure still did not satisfy the obligation. And so that the seizure, I agree that there is well-established case law that is, the source of payment is not particularly relevant. However, that NRA ACV looked at the voluntariness of, are you able to pay and did you voluntarily not pay? In that case, there was a tax refund seizure, I'm sorry, not a tax refund seizure. The amount paid was, the holding in that case was that the $200 paid was not sufficient to satisfy the overall obligation. That is the same here, is that the tax refund interception that occurred did not satisfy all of the obligation. As far as whether or not it was applied to current support versus arrears, I do think that's the crux of this case, is that had it been applied to current support, we would not be here. We would not have moved forward with an adoption.
Well, I mean, is it mutually exclusive? I'm sure the petitioner can testify, I've not received a dime. And it can also be true that $1,000 or $500 per child have been received because of the public assistance
Yes.
nature of this. The petitioner wouldn't have probably even knowledge of it at the time, 1 month later when the petition is filed.
Yes, that's a very good question. That is what occurred in this case here, arguably. It's still not particularly relevant to the period. We agree that, to answer Judge Lanziger's question to counsel, is that if mom was working, her obligation should have been much higher. I'd also concede and agree that in Ohio laws, child support obligations are twofold. There's the general obligation to support, and then there's a more specific obligation based on the child support order. Here, the child support order is the law of the land, in that my client never went back and asked for more support or modified that order, nor did CSEA. So I agree that the applicable, the relevant factor is that her obligation was in fact $25 a month. That being said, though, that the CSEA records indicate what came in. So, right, part of the payment goes directly back to the government for the assistance that the children receive. Even that, though, demonstrates that mother was not current, that this tax refund interception came in was applied to the debt of past obligations. But the question is, does the fact that she paid involuntarily through a tax refund intercept, which was applied to a debt, does that demonstrate that she financially supported her children during the 1 year period of time? And I submit it does not. The issue of the tax refund is that the fact that other case laws, including cases out of this court, have examined the voluntariness of payments, right? Is that the parent is obligated by statute to support their children out of their labor and monetary resources.
Is not the tax return out of her labor? I mean, if she's entitled to a refund, that means they withheld taxes from her, the pursuits of her employment.
Yes. I would also submit mom testified that she filed several years tax returns and also admitted, right, she's working during this period of time as well and didn't pay anything out of her labor at that time. I think that is particularly relevant herein as well, is we're not just talking just about the tax interception. We are talking that mother testified, interestingly, that she knew she could have supported the children to the best of her ability and did not do so because when she was nannying, making $250 a week, she made no effort to pay that support.
Is that relevant after the burden shifts but not before?
I think it's relevant to both. Here, the Ohio Supreme Court has long held that the ability to pay a child support obligation is the key factor in determining whether there's justifiable cause for failure to support a child, and that's in the In Re Mesa decision. The Honorable Court has held that in examining an ability to pay, that requires an examination of income from all sources, the amount of the support order, parents' entire financial obligation. And I would submit that based on that, the fact that mother additionally testified that she was capable of making $250 a week and chose not to support her children from that obligation, that's particularly relevant because it goes to her justifiable cause for failure to support. She didn't have justifiable cause based on that Ohio Supreme Court precedent and the fact that she was making $250 a week through at least half of this look-back period, yet failed to support the children from that. So could she have, during that period of time, the 1 year look back when she's making $250 a week, could she have taken her gains from employment and paid towards her obligation? Yes, she could have. And that would have gotten us not to be here, Your Honors. The fact that she didn't do that, I think, when the burden shifts to her to say, okay, here's the basic, if you didn't pay, here's the record showing what you did pay and when, what happened here, and then she admits, oh yeah, I made $250 a week, but I chose not to apply it. I think that's particularly relevant as well. So not only do we have the tax...
Finish your point, go ahead.
Yes, I'm sorry, go ahead.
Do you agree with the proposition, I think from the appellants here, that when the tax money was taken at that point, that at that point in time, mom total bill with $10 in support, or is there a different? Okay.
No, I disagree with that.
Okay.
I'm not sure really, I agree with counsel that it takes some math here to look at. Interestingly, at the time that their exhibits came in that said that her monthly obligation was $30.60, that she had an unpaid balance of $400 for each child as of December 2023. So again, we don't have records indicating that as of the period of the look-back period, she was caught up. But we say that, okay, but months later, she already has, again, $400 arrears per child. If that's the case, if their math was correct, there wouldn't be an arrears possible with the $30 a month obligation.
Well, if it was at $10 and she didn't pay for 4 or 5 more months, I don't have all the information in front of me, she'd be $1,200 or $120 or $150 or something behind, but not $400 as you.
Correct.
That number doesn't seem right to you when you see she owed $400 as of whatever date you're signing. We can look at the record.
Yes,
But the main point is you dispute it got down to $10.
correct. In closing, Your Honors, I would just certainly submit that the trial court here, there's two standards of review on this matter. I believe it's an abuse of discretion and a manifest weight argument. Both of these is an abuse of discretion. I do not believe that the records before the court would indicate that the court was unreasonable or arbitrary in that. They relied on both testimony and the records produced, and the testimony established from Mother herself that she was capable of earning income during this period of time, chose not to apply anything to her support. As far as the manifest weight of the evidence issues go, the court also clearly was in the best position to weigh the credibility of the witnesses as well as what they were speaking to there at trial, and they essentially determined that Mother was not credible because she admitted that she was capable of working during that period of time, did in fact work, and yet did not apply any of her monetary earnings towards the support application. I have nothing further unless this court would have additional questions of me. Thank you, Your Honors.
You have approximately 2 minutes and 40 seconds.
Thank you, Your Honors. 3 points on rebuttal. First, most of what the Weavers just talked about is about justifiable cause. There is simply no authority that the voluntariness of a payment has anything to do with this first assignment of error. In fact, the 6th District in Kessler rejected that because it noted that really all child support orders are involuntary to some degree, and that instead of getting into a weird line drawing problem about what is too involuntary to constitute support, it simply said, we're not going to draw a line, right? Is there support or is there not support? That's the question. Judge Hensel, to your point on at record item page 61, this is the trial court's decision, pages 3 and 4 of that decision. It is clear that yes, this whole analysis turns on whether the seized tax return payment was counted or not. I think it can't be any clearer that that was the basis for saying there was no support during that time. And then the third point, that Ms. Lovejoy somehow submitted the wrong records, or that it was her burden to show that she was caught up. No, that is not the law. It is the Weaver's burden to show that during the look-back period, that Ms. Lovejoy did not provide the support that's required by law. The latest that the Weavers submitted any records were July of 2022. That's where this $10,000, or that's where the $1,022 total outstanding obligation comes from, is from the Weavers' records submitted. Again, it's their burden to show that there was that if they think there were some other payments that she missed, they've got to submit evidence of that. But if you take that record, that's a record item 8, the Weavers' records, if you take that, you subtract the seized income tax return payment, Judge Stevenson, what you get is $10.22 left over. And the only question is whether that $10 or possible arrearage across both children, whether that somehow defeats the need for Ms. Lovejoy's consent, despite the fact that that seized income tax return was 140% of her annual obligation for both children during the look-back period. I think, Judge Stevenson, to your point again, that is a factual question that I think the court needs to, at minimum, send it back to the trial court to determine in the first instance, because, to Judge Hensel's point, the trial court did not consider the seized income tax return payment whatsoever. So for all those reasons, as well as those laid out in the brief, I think it's pretty clear here that the seized income tax return payment must be considered as a matter of law, and that considering it establishes that Ms. Lovejoy paid her obligation during the look-back period such that her consent was required, and the court should reverse. Thank you, Your Honors.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.